One of the benefits of having a subcommittee is we don't necessarily need a quorum. But we're going to start at the bottom with Senate Bill 443. If Senator Summers is here. My understanding is you have a substitute.
Yes, sir. You all should have it in your files, man.
All right.
You want me on 3 or 2, no matter?
Either one.
I think you've got the committee sub, Mr. Chairman, and that is going to be LC 394927S.
Okay. All right. We've got it.
Got that?
So you can go ahead and present.
Okay. Are we doing a hearing, Mr. Chairman? Is that what we're doing?
Well, it depends. So what we're going to do is we're going to hear your bill. The subcommittee is going to make a recommendation if we feel like your bill is ready to move forward to the full committee. We can amend the bill here, and what we'll do is we'll send our recommendation to the full committee to take action on.
Thank you. That's good. That's perfect. No problems whatsoever. Mr. Chairman, the original bill, Senate Bill 443, I drafted that bill and worked with Ledge Council on that bill because I simply remember, if you remember a year or so ago, we had all the people out in the middle of the street out here, blocking the street between here and Victory Plaza out here. And the State Patrol was having to remove people in and off the street, in and off the street. And I simply walked down there and I asked the State Patrolman, I said, can you not arrest these people? And he said, well, I just don't know what we have, what we don't have in regards to what we can do and what we can't do. And I thought, well, that's a pretty honest answer. But he said, right now we're just trying to get them out of the road. And he said, I said, well, if there was some teeth in something that, might fine people and whatever, I don't have a problem with anybody protesting. You can protest all day long. I don't care what you protest on. My position is simple. You can't block any roads because then you're blocking ambulances, fire trucks, mothers picking up their children, taking them back and forth to school. I mean, all the above you're blocking, those type things. So that I came back with this bill here and worked with Ledge Council over the summer, and this is what we came up with here to change the definition of what you can do in regarding as blocking. And if you'll notice on line 13, just to go ahead and give you the changes on line 13, we took out sidewalk or other public passage. Now, I took that out because they have to stand on sidewalks, they have to be on sidewalks, and that's part of the deal. And that'd be up, the city, county that they're in. So that was okay, and everybody, and I think we're all on board with that change there. And then if you'll look on line 17, on line 17, the original bill said of such offense results in. We're changing that to say that of such offense is the actual cause of the infliction. And you'll notice that's already in the sub. That's already in the sub. And of course, on line 18, it says property, the person, and then destruction of the property, and it says the person, and then I put in here, and it's going to have this: inflicting said injury or property damage shall be. And that narrows it down to the person that would be causing the injury or the harm, like throwing a brick, throwing a rock, throwing a bottle, et cetera, inside a gathering or just cause they're mad, that type thing. Protest all you want to, just don't act a fool, that type thing. And that's what it's designed to do. And this sets up what they call a high and aggravated, and as an attorney, you'd probably be able to give me the definition of that better, but it's a high and aggravated misdemeanor, which means if what I was told was correctly, it can be treated as a felony. If the courts so decide to do so, or the DA who would push that, and there's a $5,000 fine that could be imposed on that individual. And I think the $5,000 fine, knowing it could possibly be a felony, Mr. Chairman, would get their attention and tell them to protest in an orderly fashion. And that's what this bill is designed to do, and that's it. And we have a lot of laws out there, but that's what this bill is designed to do, to strengthen them and just kind of narrow it down to protesting and blocking roadways.
All right. Do we have any questions from committee members? Anybody sign up to speak? All right. Chairman Watson on number 3.
Just on line 18, it says, you said there was a change there, or not a change? The person
Yes, sir. There's a change. Senator Watson, there's a change here. You've got the change in the committee sub.
So the person who inflicts such bodily injury. Exactly.
It just simply said before, it said the person shall be guilty.
Okay, so tell me about is there such a thing as, what's bodily injury mean? I mean.
The way
Scratch doesn't, to me.
No, not that. Bodily injury means like
That's a
someone
bodily injury.
Well, as a doctor, you would know more, honestly, better than that, but I mean, this is more designed for someone throwing a brick, throwing a bottle.
I get it.
That type thing.
That's.
Now, if you want to narrow it down,
dangerous.
I would accept anything you want to do to narrow it down, but I mean, obviously, spitting in somebody's face, in my opinion, is a bodily injury.
I won't argue that. So, I mean, it could be deadly.
Exactly.
Spitting bodily, but and a scratch could be deadly too, for
Yes,
that
sir.
matter. But
I have no issue with tightening it up, so that's not
personal
a,
such, I don't know, serious bodily injury, or, I don't know. I mean, if you're talking about, I mean, if they're guilty of this, they've got to be fined at least $5,000, and they've got to be imprisoned for 5 years or more.
if they're guilty, that's right.
If they're
That's the
guilty.
highly aggravated nature of
It's
that.
one of the other or both.
Yes, sir. That is correct.
I mean, that's.
And I agree with you, that bodily injury is hard to describe, and that's why we left it open like that. But I'm certainly agreeable to amend it to wordage that you feel is necessary.
I mean, I'm not law enforcement, but to me, serious would be, is that a legal term?
Yeah, I would think you probably have multiple charges here on this one, Senator, on this bill, because you have the offense of the blocking, and then if there's a bodily injury, whether it be aggravated assault, whatever that may be, that would be an additional charge that would carry with it, but the underlying charge would be the first one, which would be the blocking. So the way I read this or interpret it is, there'd be a multiple charge here, one for the obstruction of the highway or street, then another one for whatever that injury may be, and whatever that charge may be, so.
So is aggravated assault,
Yes.
is that an abrasion? I mean, I really don't know the answer to that.
No, you're probably looking, abrasion probably falling under the category of battery, or simple battery, one of the two, and ag assault carries its own felony charges for that.
So is the word serious is not needed, or it does clarify it?
You bring up a good question, because it's like we're trying to merge two different things in one, but for the intent of this bill, I don't think it would be. We got a excellent lawyer sitting to my left chair in the committee, if he would like to weigh in on this as well. You got the old law enforcement stance here, if you.
Yeah, no, I mean.
We got a chairman law enforcement, sitting here, lawyer,
You don't get legal counsel?
and one, two.
Yeah, when he gets back, because I'm more of a civil attorney, I don't do a whole lot. My law partner could help. I think those are good questions, and
Line 18.
Honestly, I think you could almost strip everything after a higher and aggravated misdemeanor.
443, I'm sorry, guys.
Blocking the
443.
interstate or the highway or street, that is a charge that he is looking for the high and aggravated misdemeanor.
we've got some people that are signed up to testify.
Okay.
If we want to hear some testimony first, then we can circle back. First, we have Sarah Hunt Blackwell.
Senate Bill 443. Okay.
Thank you. If you don't mind just introducing yourself and your organization.
Absolutely. Good afternoon. I'm Sarah Hunt Blackwell. I'm Senior Policy Counsel at the ACLU of Georgia. I'm thankful to be here this afternoon and for this discussion. I'm here testifying in opposition to Senate Bill 443 because it expands criminal liability for First Amendment protected protest activity. So protests can come about in a number of ways. Some are pre-planned, with organizers submitting permit requests and road closures well in advance of the protest itself. Some come together more spontaneously in response to current events. And we know that the pre-planned protests receive First Amendment protection, but the United States Supreme Court has made clear that spontaneous demonstrations are also protected by the First Amendment. So this means that people can literally take to the streets without the formality of requesting permits and road closures within a certain time frame after a newsworthy event occurs. So SB 443 undermines the First Amendment protest protection by discouraging people from protesting newsworthy events in public roadways due to the possibility of arrest, prosecution, and imprisonment. So this bill also imposes concerning penalty enhancements and mandatory minimums. No harm or injury whatsoever is required in order for someone to be charged with a high and aggravated misdemeanor under this bill. This is the same criminal liability that is applied to people who are charged with battery against a pregnant person, reckless driving, or a third conviction of DUI. Merely obstructing a roadway pales in comparison to these crimes. In that same vein, a mandatory minimum felony charge for any type of bodily injury or property damage, I think kind of to Senator Watson's point, is also extremely concerning. Felonies in Georgia usually apply to violent crimes and other offenses that result in extremely severe outcomes. As written, someone could face at least 5 years in jail, pay at least $5,000 in fines, be stripped of their voter status, experience difficulty gaining employment and housing, among other consequences, if their road obstruction causes injuries or property damage, no matter how minor. Quite frankly, the punishment doesn't really fit the crime. Multiple sections throughout Georgia Code already establishes penalties for the conduct that this bill seeks to address, and there's no need to increase the criminal liability or impose a mandatory felony charge for conduct that may not even result in any real harm. For these reasons, we respectfully ask the subcommittee to vote no on SB 443, or at the very least to reconsider the language and consider amendments that balance the liability of the offense. Thank you for your time and consideration. I yield for any questions.
Thank you very much. Does anybody have any questions for the presenter? All right, Senator Jones, number 11. Got it.
11. On the one line that I think you're referencing, line 17 on the bodily injury.
Yes.
Would you replace that with serious bodily injury? Would that be one step?
Yes.
Can you tell us any other steps that you would have possibly to kind of work through this?
Absolutely. So definitely adding serious bodily injury. Also clarifying the destruction of property, a clarifier that you all would deem fit, but something that's a little bit that goes to the seriousness, the severity of whatever that property damage would look like. Also just recommending to keep the law the same and not increase the penalty to a high and aggravated misdemeanor, and just keep it as a regular misdemeanor.
All right, thank you. Well, I do have one more, Mr. Chair.
Yeah, go ahead.
On the destruction of property, if you put a numerical value on there, would that help? Or, 'cause I see what you're saying, 'cause destruction of property could be very vast. You're trying to tighten that up. And how would you want to tighten that up? Just curious.
So I don't know the code by heart, but I think that there are numerical values placed to the level of property damage in the code. So if there were numerical values placed in alignment with what already exists in Georgia Code in terms of something property damage raising to the degree of a felony, that could be appropriate.
Right. Probably still wouldn't want to be a felony, but I understand what you're
Right,
saying.
exactly.
Yeah,
But still, those
Yeah.
delineations are important.
Right, I got you. Thank you, Mr. Chair.
Any other questions? Senator Bearden?
Are you correctly saying that if a protest, or if a spontaneous protest broke out and they shut down 75-85, that's a First Amendment right?
Within a certain time frame.
What time frame would that be?
So it depends on where you are, but generally the courts have said anywhere between 48 to 72 hours.
So
After a newsworthy event has happened.
I also believe they may mention about public safety as well in there. I think we'll have to, I'll have to respectfully disagree on that one, but I appreciate you answering the question.
Thank you.
Any other questions? All right, thank you very
Okay.
much.
Thank you, Mr. Chairman.
Next, we have Brian Hines.
Hi, everyone. My name is Brian Hines with Gactyl. First of all, I just want to say we had a chance to speak with Senator Summers, and it was really helpful, and really appreciate him taking his time to chat with us about it, too. From what I understand with this bill, it does predominantly two new things, right? You have the misdemeanor that's being changed to an high and aggravated, obviously no injury that occurs or property damage. And you've got your second portion that obviously is property damage and injury. What we would suggest would be just to leave the high and aggravated portion, and the reason being is because I think, as you've all discussed, there are already statutes that cover this kind of conduct, so it already can be criminalized. So, for example, if you actually have the injury that occurs, you could probably get on aggravated assault which carries a sentence of 1 to 20, if I recall correctly. You have battery, you have aggravated battery. There are other things, and there's also criminal damage to property, which at least in the second degree, I think is at least $500, and I believe that's 1 to 5 years punishment as it is. So if somebody were to obviously damage property and commit injury, they could be already nailed for 2 of those crimes, and I think that's sufficient. But we obviously did defer to the committee, but just I think that there's enough stuff in place for prosecutors as it stands. Thank you.
And I have a quick question. So the number you just referenced, the $500 for property damage,
Sure.
is, Senator Jones was asking about that earlier. Is that the magic number to trigger a certain level of a crime?
At least in the second degree it is. I don't recall what the number is in the first degree. I think there might be a different valuation there, but generally that is the number, yeah.
Okay. Any other questions? All right, thank you.
Thank you.
All right. So, Senator Summers, the posture we're in right now is we can take action and move this bill to the full Judiciary Committee with our recommendations. Or we can work on it a little bit more. I'll defer to you right now as to what you'd like to do. If you'd like us to, I can entertain a motion to move it forward, or you can go back to the drawing board a little bit.
Mr. Chairman. Am I on 3?
There
Mr.
you
Chairman, of course, I will yield to the brilliance of this committee to determine which way I need to go in regards to that, but I'll tell you, weakening the bill and going back to what the first person testimony a while ago was not, in my opinion, put any teeth in the bill about someone's blocking a highway, a road, or a street, or whatever. I don't have any problem with anybody protesting. I'm all for protesting. I just tell you up front that, that's why she doesn't want you to pass this bill, because it allows people to block a road or street or highway. And by doing it this way, it's enough teeth in this bill that you don't. Now, what Senator Watson said, and what Senator Jones just said in regards to putting the word seriously in there, I'm amendable. I'll yield to the lawyers on that level, you guys to tell me. But I want the teeth to be in the bill to let people know. Protest all you want to, just don't block the roads.
Okay.
And I don't believe, and I share what Senator Bearden just said, I don't believe you can go block I-75 and 85 and 285 and all these different roads and Peachtree Road. I just don't believe you can block these roads, and you should be allowed to.
Okay. Yes. Oh, there we go.
Thanks, Mr. Chairman. Thank you, Senator Summers. I'm sorry that we were headed off to CLOB.
I did the same thing.
So anyway, I missed your initial testimony, but so I don't disagree with you about it's not going to work for community, public safety, et cetera, for, highways to be blocked for, days or 2 days or whatever. And it doesn't seem to me that actually is permissible, because we already have this existing code, right? So a lot of what you just said, I'm like, yeah, but we don't do that. And we already have it as a misdemeanor.
Right.
So if I blocked a road for just a few minutes, or let's say a half hour, but there's no damage, and it's a little bit of a disturbance to the commuters for a half hour, which is typically I'm in my memory, and certainly we've been in an era where there have been a lot of protests, maybe the most in my lifetime. I don't recall any highway blockage that was more than 10 minutes. So I kind of think that's not really what we're so much talking about. Why is a misdemeanor why do you think that's not okay for my behavior of being on 75 for a half hour?
Well, I can't speak as an attorney, legal nor court, but when I worked with Ledge Council on the bill, their suggestion was to make it a highly aggravated, so it can still be a misdemeanor if the courts decide to, but they can also be charged with a high and aggravated, which raises it up from a standard misdemeanor. And that's on front page, down on line number 16. Well, on the sub, it'll probably, number 16. It changes it to a high and aggravated. And that's why it's on the line, because that changes it, gives the definition, and obviously supposedly puts more teeth in the bill.
But it's already a crime. You agree with me?
Yeah, well, I've got the code section. You're right. It is already a crime.
Yes, it's already a crime, right? And so what is your understanding of the penalty for my, hypothetical behavior, blocking the highway for a half hour?
Well, I got 2 or 3 answers on that question.
Right.
So,
Can I finish my question
yes,
just to make sure that And obviously I did it with some friends.
Right, right.
Because I can't block 75 on my own. I probably just get mowed down. So, now, what would be my possible penalties for my misdemeanor under current law? And what would be my penalties for me and my friends' half-hour blockade of 75 under your bill?
Well, if I understand correctly, once again, I want you to understand these, if I may be so bold, we got so many laws out there in regards to how these things designed. Sometimes we don't, they all kind of conflict and kind of run together. And you get different answers when you ask the questions, if you ask the question a different way. So when I asked Ledge Council about this, a misdemeanor can be $500 plus or minus whatever the court said. The high and aggravated allows it to go up to the $5,000. It changed it. That's what I can tell you that I know to be true. That's the only way I can explain it to you.
Well, I believe there's jail time considerations with both, right?
Well, you were asking about the money. I'm sorry. Yeah.
Oh, no, I was asking about
I'm sorry. Yeah.
both. I mean, those are both parts of potential penalties.
Yes, a highly and aggravated, according to what they said, could be considered a felony because it changes it from so many months up to 24. Anything 24 months, if I remember correctly, doing the work research with them, can be considered a felony.
So I guess the question for the committee is, it's already a crime. We already have a penalty on the books. Do we feel like there's such a big problem with, I live in Atlanta, this behavior that it's really necessary to?
Well, we don't. I guess the question would be we don't know what may or may not be coming in regards to the protesting of any. I mean, anything could be protested. I'm just saying they can protest all they want to. I don't care. I'll protest with them. I just don't want them to block those roads, and I want to put enough teeth in something to keep them from blocking those roads. That's the intent of the entire bill, and I see it and know exactly where you're coming from. And you have obviously a legal mind that can tell me that, but we do piggyback laws quite often.
All right. Are there any other questions? I know we had some late arrivals, yeah? Chairman Cowser, number 4.
Mine might sound dumb, but on line 13, you are striking through street, sidewalk, or public passage.
Sidewalks are other public passage.
Okay, street's still there.
Yes, sir.
So now it's not even a misdemeanor or a crime of any sort to block a sidewalk or other public passage?
Well, Senator,
Just making sure that's what it does.
right now, that you'd be correct. I just couldn't figure out how people are going to be anywhere if they're not on a sidewalk. I mean, they got to be close to the street if they wanted to protest. So,
I see.
Yes,
Okay.
sir. Yes, sir.
Yeah. All right.
You got a full committee, Chairman.
Now we do. Any other questions?
And I'm amenable to amending the word, what Dr. Watson has said, if he wants to do that or whatever, but I don't have the legal mind to tell you that word changes anything or not.
Well, let's not get ahead of ourselves. Let's see what the pleasure of the committee is. So we have a motion due pass from Senator Bearden.
Can you clarify that the motion is to recommend it to the full committee?
That's correct.
Yeah.
Yeah.
Sorry.
Are we going to be able to amend this shortly?
Yes.
Okay.
Yeah. If there's a second.
Pass it for the committee.
Yep. All right, second from Senator Watson. Are there any amendments? All right, Senator Bearden.
Stick with me here for just a minute there, Senator.
I'm gonna write it down if you don't mind.
Well, you're going to do more striking than writing. On line 16, and Legislative Council may have to help me here, after the words high and aggravated misdemeanor, I think we need to go with a period, strike everything through 17, 18, 19 to line 20, striking all the way through the words 5 years or both, period. And then go with in addition to any other fine, penalty, or restitution which may be imposed, and the rest of that to go in there. For me, and maybe for Chairman Watson, I think this language that we're striking was a little bit messy, because there could be other charges that could be handled if there is an aggravated assault with a vehicle or whatever. And this will still allow the penalties that you're looking for, I think, which is trying to block the highway or street to still get that high and aggravated misdemeanor, but then this bring in also allowing civil liability for damages if it needed to be.
And you're sitting in that position, I mean, you're saying it's still saving the fact that they can't block streets or the road.
Correct. What we're saying is your intent for a high and aggravated misdemeanor, and now we got another attorney in the ring, which would be helpful. That would get to what you're trying to do.
So just to clarify, the amendment Senator Bearden is proposing on line 16, the semicolon after misdemeanor would be turned into a period, and then starting with the word provided, we would strike everything until you get to line 20, and you would strike all the way through not less than 5 years or both periods. So that would be
Then picking up the new
stricken, and then it would
sentence.
say, in addition to any other fine, penalty, et cetera.
Correct.
One question, Mr. Chairman. Bodily harm, injury for the lawyers on the thing, is that still, how do we deal with that?
My philosophy on that would still be where we were talking about earlier with me and Chairman Watson. If there's another crime that took place, that would be handled on that charge, if that makes any sense. Or am I
with you,
clear with
yes.
you on that one? So I
Yes.
was just trying to make sure we're both on the same page.
yeah.
You know, we're getting from blocking to now we're getting into bodily injury, seriously bodily injury. And so I think to get to your intent, which is blocking the highways or streets,
Okay.
to that high and aggravated misdemeanor part, then if something happened that causes another crime,
All right, so-
aggravated assault or whatever, there's going to be another charge.
We've got his amendment. You want to second that amendment, Chairman Watson?
Yeah.
Any other discussion on the amendment? Okay.
Just a point of clarification.
Number 3.
3. Point of clarification, what we had mentioned for those who were over in the previous meeting place, is that we had talked about that you could still get charged for aggravated assault or battery or any of those lesser or minor charges, whatever would be appropriate. So that's not taken off the table, but it is still there. And this still does allow for civil liability. In other words, you can be sued. And that could certainly be more than $5,000
Exactly.
for that matter.
Yeah, I'm okay with it.
All right. Senator Cowser?
In discussion, I do support the amendment. I think it makes it better. As I understand it, it still increases it from a simple misdemeanor to high and aggravated, but it creates a civil cause of action, a new tort. But I don't know what the damages would be if it's not a bodily injury or damage to property. I don't know what kind of damage there could be from, I guess somebody misses a doctor's appointment or something if the highway's blocked. I mean, I
Airplane or-
can't imagine what exactly that damage would be. You know. Yeah, I guess, yeah, but I just make that observation.
Senator Watson?
For us non-lawyers on here, tell me, what do you get with a high and aggravated misdemeanor versus a misdemeanor?
Senator Cowser?
You serve more time in jail. You're less able to, get time off for good time served. And I think you have to spend, I want to say it's 75%, but maybe Mason Lynn or somebody's here that does more criminal defense.
Ledge counsels.
Jail time stays the same. It goes up to potential $5,000 fine. Yeah.
Can you get the day-to-day time off for good time served if it's high and aggravated? I know
think
you
that's
don't
usually
in
up to
Clark
the
County.
jail, yeah.
Maybe up to the sheriff.
The day-to-day is usually up to the sheriff, right?
No change on days off for good behavior.
Okay, so according to Ledge counsel, it's just 1 to 12 months. The fine is the only difference?
Yeah, the fine's only 2 months.
Okay.
And with this amendment, I would recommend also on line 3, that we would strike through about midway through line 3, and for enhanced punishment in certain instances.
Senator Bearden, are you good with that change that he just recommended?
I am.
For your amendment? So in addition to Senator Bearden's amendment, it will also be on line 3. You would strike "and for enhanced punishment in certain," and then line 4, instances. All right, so we've got a amendment. We have a second on that amendment. All those in favor of the amendment, please raise your right hand. It is unanimous. Are there any other amendments? All right, so on the bill to be recommended to the full Judiciary Committee, we have a motion to pass as amended. All those in favor, raise your hand. It's unanimous.
Thank you, sir.
Thank you. Oh, sorry, excuse me. All right, all those opposed? There we go. We have one opposed.
Thank you, Senator.
Thank you. All right.
Thank you, Mr. Chairman.
Up next, Senator Brass with Senate Bill 406.
Here or there?
Wherever you prefer. You want down here or up there, you can pick.
I'll go here in case someone.
What has to do has to move to full committee. That's the same. That's what Jack told me. All right, Mr. Rules Chairman, the floor is yours.
Thank you, Mr. Chairman. Ladies and gentlemen, I bring to y'all Senate Bill 406, and we're working off of LC 4434007 ERS. I hope y'all have copies of that.
We got it.
All right. So let me first tell you how I got involved in HOA stuff. Senator James started working on this probably 4 or 5 years ago, and had a study committee on it, maybe even multiple study committees on it, and she has had some proposed legislation that has failed to move. But the intent she had was good. And one of some of the people that spoke at her subcommittee or study committee were constituents of mine, and so she had put them in touch with me, and I ended up, they asked to meet with me at 7 o'clock on a Friday night. They told me they would have 30 people there. So at 7 o'clock on a Friday night, I was thinking probably 2 or 3 people would be there, but I agreed to do it. We meet, and 30 people showed up, and 30 people were having different issues with the same HOA. And that was really just kind of a microcosm of a bigger issue we have going on in this state. Because right now with HOAs, there's very little accountability. Should a homeowner or a property owner have an issue with an HOA, really their only recourse right now is court. And that is, so for many of our homeowners, many of our citizens, hiring an attorney and going to court just simply isn't feasible. And so I wanted to come up with something that, number one, there was an accountability piece. We have no idea how many HOAs there are in this state. HOAs, COAs, POAs. So we wanted to have some sort of registration, number one, so we could figure out how many's out there. We think I've heard anywhere on the low end about 11,000, on the high end 20-something thousand. I think 22 is the highest number. So I would guess it's going to fall somewhere in between there. So the overall goal of the bill, number one, like I said, was accountability. Number two, I wanted to set up an administrative hearing so that court wasn't the first and only option. And then three, I wanted to come up with a Bill of Rights. That Bill of Rights is really kind of reminding people of what their, in some cases, constitutional rights people were losing. Wanted to remind them of that. And the Bill of Rights is really kind of pulled from different code sections that are in place. And then fourth part of this bill, and one of the big issues we had is foreclosures. A HOA or a property owner association, they can foreclose on a home if that homeowner or property owner owes $2,000. And in my mind, $2,000 in today's world, on the cost of a home, that's in many cases that is their generational wealth is built in that home, and they can lose that overnight over, something as simple as not mowing your grass properly or in time. So we've addressed that. So that's kind of the four main sections of the bill. And I'll kind of go through that briefly with you. In section 2, we get into, there's going to be two types of associations here. One is a non-registered property owners association. These are where everybody's getting along, don't want any changes. Everybody's doing what they're supposed to do. And so they don't have to register, but they would have to send a written statement to the Secretary of State's office saying they are a functioning HOA, and they will have the ability to collect dues and assessments, and that's it. They can't assess fines or fees. So that's, again, just so we're clear, dues are, what you collect to, kind of keep up your common areas, things like that. Assessment is should that common area, like a pool or something, need an upgrade or just a major overhaul or something, they would do an assessment to everyone, and then it's for a capital improvement. But they would not be able to issue any kind of fines or fees. Now, for the other ones, these property owner associations, they would file with the Secretary of State. They're going to file their bylaws. They will file their financials. They will file the address of the property owners association where that resides, and then the list of their officers. And they will have to do this yearly. We're doing $100 for that registration fee. Again, they would do that. They would do that yearly, and it would run once you get all that filed. And these are all things that they're supposed to be keeping up with anyway. Again, going back to the issue I had with my constituents, they were saying they couldn't get copies of the bylaws. They couldn't get copies. They couldn't see where there was ever an election. None of that stuff. So in filing it with the Secretary of State's office, now it is, really is subject to Freedom of Information Act, and anyone can go get that at any time. Moving on, let's see. Getting into we're going to set up a board. This board is where the hearings would take place. The board would be appointed by the governor, lieutenant governor, speaker, and should there be a grievance, it would go to this board. The Secretary of State's office also can assign an investigator to look into this stuff. And they can also, that investigator will have the ability, should the Secretary of State's office deem that a property owners association is not viable or hasn't done the proper steps, they can throw it out. Should they complain, that investigator can look into that matter, but they can also look into matters for these hearings that the board could hear. Again, that is the administrative process. Versus having to go to court right away. I'm on page 5, but I'm not sure that's what I'm talking about. So if you, hold on, let me look. So line 251, that kind of gets into your complaints. In fact, let me just go off the sheet. It'll be a little more organized. All right, so line 251 kind of covers your board, and a lot of this stuff. Keep in mind, the reason we chose the Secretary of State's office is they already oversee nonprofits, and they're already getting a lot of complaints about HOAs. They just don't have any mechanism to do anything about them. So they're getting the complaints. They're set up. We took a lot of the same laws from the nonprofit law and applied it to this. So a lot of this stuff you're seeing essentially a copy and paste from that code section of our law. Now, if you move on into line 335, that's where we get into the Bill of Rights. And I'll cover a couple of things. I'll tell you that are that has been debated in working with people on this is the first one is on is at line 347. I've got in there 1 vote per individually owned property on each matter voted on by the members. To me, in a case of, let's say, like a developer owns, I don't know, 200 properties, and he has sold off maybe half of them, he would still have a vote for each one of those remaining 100 properties. So I think this would help in the transition of that developer to the HOA. Now, it would be in his or her best interest to stay in good graces with these HOAs, because once he gets outnumbered, he's going to want to protect his remaining investment. But at the same time, they're going to want to protect their remaining investment as well. So I think the transition there should go a little smoother. There are some contracts out there and this is more specific to COAs, your condominium associations. In some cases, a guy, let's say on the penthouse, and he owns the whole, 10th floor, his vote is weighted differently than those underneath him. And I say underneath, I mean that literally underneath. So in my mind, I don't like that idea. To me, that's saying the guy that owns 10,000 acres should get more votes than me that owns 0.4 acres. But that is one part of this bill that is a little contentious, because there are already bylaws out there and contracts out there that do reflect that. So I would yield to the committee judgment on that part of the bill. Another part is when you get into lines 365 and on down, we're saying that property owner has the right to display an American flag. They have the right to do political signs. They have the right for religious and holiday signs. And it's been brought to my attention, if you're going to pick some signs and not others, it could be First Amendment rights. Again, that part could be a little, I guess, contentious. I'm okay if that part goes out. Again, my main goal here is accountability on the HOAs and the administrative piece, and then just understanding these other basic rights that you can read for yourself. Section 3, this is on page 16, that gets into the foreclosures. We're taking it from $2,000 up to $4,000, and then we're saying that no fines or fees can count towards that number. And what we have heard in the past, that some of these runaway boards or board members, they're fining and feeing people to death and then foreclosing on their property. And so I think this takes that away. But you got to understand why that language is there, and why the foreclosure is there is to give the associations the ability. They got to have some sort of mechanism to enforce people to pay those dues and pay those assessments. And so I feel like we need to leave it there, because there is no other way to make them do that. But I did double it because that $2,000 is, I don't know how long that's been there, but we haven't touched it in my 10 years. I know that. So that's pretty much it. I'll say on line 412, we did take it from 4 years to 6 years on looking back on the dues. The reason being, there are some HOAs out there that there's such a small amount that they're collecting, that 4 years, someone cannot ever pay their dues at all, and in 4 years still not hit that $4,000. So I did take that from 4 to 6. So that's the bill in a nutshell, and I'll be more than happy to answer questions.
Thank you. Do we have any questions? Senator Bearden.
Bearden Show. Mr. Chairman, quick question. getting a lot of good feedback on this, but I did have a couple of questions. We got a very large HOA in my district, but we also have a lot of small HOAs. We're talking 25, 20 houses less. As you said, basically keeps the lights on for the street lights in a very small section. Is there anything that may be able to be carved out for something on that small of a size, or?
Well, I think the what do you call it? The non-registered property owners association, they would fall under that. They can still collect their dues. They can still collect the assessments. They just can't fine and fee people.
Okay.
So those small ones are typically not going to be the problem.
Correct. And you said between lines 365 and 378, you wouldn't have a problem seeing that removed?
Yeah, I'd be okay with that. Just as again, I'm trying to keep this bill with as least opposition as possible.
Yeah.
Because the important parts to me is the accountability and is that administrative piece, and then the foreclosure.
Because I agree, I don't think we can cover every possible display that could be put out there, and this may make it easier to just remove it than keep it.
Yeah, no, I'm completely good taking out line 365 through 378. I would have no problem with that.
Okay, do we have any other questions? If not, we've got one person signed up to speak. Looks like, oh no, we don't. We have more than one. So we'll start with Betsy Bradfield with the Georgia Realtor. Absolutely.
On line, number 3, on line 382, number of occupants, household be members of a single housekeeping unit. Did we define what a single housekeeping unit is? That could be a cult of 250 people in someone's home. I'm just throwing that out there. Maybe that's defined in law somewhere.
Yeah, I do think that's defined elsewhere. That's basically if you have an HOA that says you have to, only one family can live in a home,
Right.
then they have that ability. We're leaving them that ability to do that.
And I concur with that, but I just, just wondering, we're putting it in law. That's.
I believe it's already in law, but I'm not 100% sure on that.
Yeah.
All right, let's hear from our first witness.
Thank you, Chairman. Thank you, Chairman Brass. Betsy Bradfield, Advocacy Director for the Georgia Association of Realtors. First off, wanted to thank Chairman Brass for putting this together. I know it was a lot of work, especially over the off-season, meeting with different constituents and other groups to determine the best plan of action to go forward. We've been part of a lot of these subcommittees and study committees, and it's been a lot of work, a lot of public testimony, but we appreciate this fair and balanced approach that you've come to when it comes to this bill that provides a lot of really necessary guardrails and ensures accountability for homeowners who are currently living in HOAs, COAs, and POAs. And it ensures that, a lot of times homes are the largest investment someone's going to make in their entire life, and this bill puts on those necessary guardrails to make sure that they can do everything in their power to stay in that home with raising that foreclosure threshold. But also, realtors live and die by the contract, so as a homeowner, you should know what you're signing when you sign your closing documents to move into that home. So this will also allow them to hold their homeowners associations accountable. There are plenty of good actors in the marketplace, but there are some bad actors that appear to be spoiling it for everyone. So they will be able to hold these these associations accountable with the accountability board that is being created. Because as Chairman Brass said, right now there is really no recourse for you. Your options are to sue, and it's really difficult to find an attorney who will take that suit because it's very hard to win a case. So we are looking forward to this bill hopefully passing the Senate and being signed by the governor. So happy to take any questions.
Thank you very much. You have no
Thanks, John.
questions. Next, we have, looks like Janelle Carroll Menifee.
And good day to you fine people. Our most honorable senators, thank you so much for allowing me to speak before you guys today. It is such a coinkydink that I'm standing before you here today. I was actually meeting Senator Brass to talk about some of the issues that the Georgia Solar, I'm sorry, to introduce myself. My name is Janelle Carroll Menifee. I'm the chair of the Georgia Solar Energy Association. And our association has about 200 members in it, both installers, residential homeowners, solar homeowners, as well as manufacturers, okay? And when I was meeting with Senator Brass here, we have such an issue related to HOAs that just, you know, 1 minute the homeowner, they talk with the developer, and the developer says, you know, hey, this is a solar-friendly HOA, and then as time goes on, the homeowner chooses to eventually go solar, and as you know, sad to say, the HOA chooses, or let's say a new president comes in, and he's an anti-solar president. And that is a very difficult position for this HOA member to be in. 1 minute is pro-solar HOA. Next minute, this unilaterally, this president or this board just decides to go anti-solar, and this person has invested a large money, their resources, possibly their multi-generation family home, and they can't go solar, you know. So it's a very difficult position for a lot of people to live in under this under various HOA policies.
Mr. Chairman.
Thank you, Mr. Chairman. What I would say that in this case is the way this bill would work is, and the way these hearings would work is, because they're now filing, these HOAs are filing their bylaws with the Secretary of State, their own file. The Secretary of State's office and the board would come in and determine, are they following the bylaws or not. This bill in no way says an HOA cannot, you know, ban solar panels on your home. It just says if you don't do it, you can't just tell a homeowner they can't put on there if it's not in the bylaws. And so this is just, again, holding them accountable to their bylaws and not allowing, you know, some new president who gets on a power kick because he doesn't like his neighbor to change his mind on something.
Yeah. Thank you. Next, we have Austin Hagney.
Thank you, Mr. Chairman and members of the committee. My name is Austin Hackney, here representing the Home Builders Association of Georgia. And I want to start with a word of thanks to Chairman Brass and to Senator James and all the citizens who showed up to those committee hearings over the last several years on this topic. And of course, the Home Builders Association of Georgia is very interested in this subject on behalf of our developer members who create these communities. And from my perspective and in my experience working for these men and women, you know, 99% of the time, they're working around the clock to get these communities established, to get the homes built out and the families moved in so that they can continue on to the next project down the road and keep that turnover going. So our interest in all of these hearings along the way has been really the transition from the declarant or the developer to the homeowners and what that looks like. And as we sat through a lot of the stories and the anecdotes from around the state, it seemed like at least 90% of the stories that we heard were about post-transition issues when the homeowners are dealing with board members who are their neighbors who maybe don't see the rules the same way they do. And so I think from our perspective of the bill, as it's been described, it's addressing a needed issue. There were some really just scary stories from our neighbors from around the state that I can't imagine being a part of. So we are not in opposition to anything about the bill and support its good ideas. I've got two pieces that I wanted to point out for the committee's consideration as you decide how to send it forward. And one of those has really already been addressed in the sub that was described, which is the differences between those small-scale communities and the large-scale master plan subdivisions. And so, the rules that an established 30-unit neighborhood would have to work under, should be different than what a 3,000-unit neighborhood needs to work under. And so, some consideration of those differences, and certainly in the non-registered communities, that makes a lot of sense. And secondly, it's already been discussed, so I'll point it out very briefly. The weighting of votes per lot is something that's different in the CC&Rs for pretty much every community. Different developers have their preferences for how they anticipate that transition happening, but for a single-family residential subdivision and the HOA that gets created there, those CC&Rs might include transition terms that really rely on the weighting of those different lots and how many votes each lot gets. So as a developer, you might weight your developer-owned lots more heavily for a number of different reasons. And like I said, in 99% of these cases, the goal is to get to the finish line as soon as possible. And so those reasons would really be about protecting the overall community and mostly the aesthetics of the overall community in order to continue those sales and make sure that somebody buying a year or two after the initial sales, are getting the same level of landscaping, of exterior finishes, of everything that the original vision for the community included. So weighing those lots differently for a developer-owned lot versus a homeowner-owned lot, there's a reason for that. And to the chairman's example, having that list of votes per lot that the developer's holding on to for the sales cycle makes sense. And if we could continue working with the Senate and the legislature on making sure that reflects the reality of the situation, we'd love to stay engaged and appreciate the opportunity. Thank you.
Thank you. Thank you very much. All right. Next up, and I cannot read the first name, is it Mason Williams? Starts with the M. There we go. And just to let everybody know, it's not a hard stop, but it's a pretty hard stop at 5:30. So if we could limit the testimony, just try to keep it as brief as possible because we've got a couple other bills that we need to consider today too.
Yes, sir.
Thank you.
Marion Williams, HOA president, homeowner, part of the HOA, commercial real estate background. I want to make sure I'm hearing it right because I had an issue when I first came in. Subdivision on the 5 years old, 212 houses, only 31 people were paying. So I want to make sure that 100% we know that not everybody owns a house is honest. And we want to make sure that they will not penalizing the honest people because people come up. For instance, if you come home intoxicated and hit your garage, you have to fix that. And I think the stick is a $25 a day fine. And until we tell you, until you get to the point, we say you need to fix it. That's 30 days, 60 days. But after that, only thing that helps is the stick, is a fine. And if we stop fines, only reason I pay my light bill on time because Georgia Power will fine me. And they have the right to cut the services. As an HOA president, I cannot cut the services off if you don't pay. So I want to make sure that we are not, again, we want to keep the communities we need HOA dues to pay the community. My subdivision, when I took over again, we had people self-contracts. I went to the Atlanta Business Chronicle and found the top 10 homeowner associations. They recorded. I chose one of them. We have no problem. It's the self-managed people who are, I believe, that's dipping into the pot. So I just want to, the 4,000, we have 5 years old, we still have people who haven't paid since they came. So if you take it to $4,000, they may go 4 or 5 years. And then after that, we have to set up a payment plan. And last thing I want to say, we don't go from 0 to foreclosure. There's a demand letter from us. Then there's a demand letter from the attorney. Then we get them, it's several things before we can go to foreclosure. Out of 11,000, you say homeowner association, there's been 1 foreclosed in 5 years. So I want to make sure we're not giving people the opportunity to park their box truck. If you can't afford this community, you can't park your box truck here. And I asked you to move it twice. You bring it back at night, and we start $25 fine a day. And you come to the Georgia State and say they're abusing me. It's not like that. And so I'm really, I don't know. I definitely know the one. I think it should stay at 2,000. Because again, it will always go beyond 2,000 when you have attorney fees. And again, we only charging $85 to $100 a month. Look how long it takes to get to 2,000. If you raise it to 4,000, they can stay. And then we have to give them a payment plan on top of that 4,000. So that's 2 years of payment plan. So I know I'm speaking fast, but I want to make sure we are not hurting these communities, that we'll work hard for. Last thing I want to say, even communities where we have swimming pools, they will go online, some people, and lease the pool out. And when you catch them, you say, hey, you can't come to the pool anymore with your family. And there's a fine if you caught. And we abuse them. I just came out of a case, someone said I was stalking her because 2 years ago I told her she couldn't go to the pool. And again, it's a case down there. We have a lot of issues with HOA. So they may take some time, but I want to make sure we're not hurting good communities for a few bad characters. Thank you.
Thank you.
Well, to be clear, Mr. Chairman, the bill, he would still be able to do his fees and fines. We're not taking that away. He's just going to have to register with the Secretary of State, their HOA.
Thank you. All right, next we have Carl Anderson. And after Carl, it'll be Julie Howard. You're on deck.
Good afternoon. My name is Carl Anderson. Thank you, Mr. Chairman, and thank you, Chairman Brass. I have served on a board as a volunteer since 1999. I think there was 2 years between today and then where I didn't serve. I'm the vice president at this point. We have a 5-member board, and we only have 32 units. And our concern is that right now we have a very tranquil, everybody gets along community, but it is possible that we could have a rogue person move in. We had that in the past where one particular homeowner would basically make us take him to court to pay. And every time we went to court, he would write a check for the back fees, the interest, and the attorney's fees. And it was just a lot of effort for a rogue homeowner. And I don't want to get in a situation where we can't find people and you're increasing our costs. So our board has always been very accountable and very responsible. I think that's how most boards are. But we have a lot of responsibilities. We have to pay the water bill, we have to pay the sewer bill, we have to pay the external maintenance, we have to take care of the road, and included in that is roofings. So since I've been on the board, the association has had to fund over $1 million in renovations or not necessarily ongoing repairs. So those are all capital projects. Those included having to have manufactured or structured walls built and other things. And I just don't think that it's wise to tie the association's hands and treat them differently than other nonprofits. Because right now we're subject to the nonprofit code, and so if you have problems with things, there are remedies in the code for that. And if there's a material change, we have to notify everybody's mortgagee under our covenants of things and under most people's mortgages. So that's a whole different level of things. If we lose our right to collect, or if somebody misses a deadline to file. And I just think that it's somewhat draconian in that sense. I'm not saying they're not bad actors. I watch the news. I've attended some of the things that Senator James has done and listened to the complaints. But ultimately, if you have a rogue homeowner, they're sort of stealing from their neighbors. And to me, this bill allows them to continue to do that if we have to jump through additional hoops. And it's not like we have a bucket of money sitting out there to pay the water bill every month, which in the city of Atlanta can be quite high. Anyway, those are the things, and I know you're under time pressure, but I just wanted to say that you hear about all the homeowners associations that are bad, but you never hear about all the ones that are good, and the vast majority of them are fine, and many of the things that Senator Brass has pointed out are covered in the code already. I could go through them all, but I don't think we have time to do that, so.
Thank you.
Thank you.
Thank you very much. All right, next we have Julie Howard. And up next after Julie is Lisa Turner.
Thank you, Chairman Hatchett, and thank you, Senator Brass. I am here on behalf of the Community Associations Institute. I am a lawyer practicing 33 years, 30 of which have been dedicated to representing homeowner and condominium associations and volunteer time to the Community Associations Institute. We have worked for many hours with Senator Brass and appreciate his time and audience for us. I want to hit on a few things that you've heard so far that I think are really fundamentally important. First, the Community Association has a foundation that does nonpartisan independent research. They confirm every year the number of associations in the state. There are over 11,300 HOAs and condominiums in Georgia, over 2.5 million people. About a quarter of our state live in these associations, but they do so by choice. You choose to move into a homeowners association or condominium association. There is existing accountability if you have a rogue board, for example, already in the nonprofit code, all of which associations must be subject to. There is a process for removing board members. And of course, you have the right to run for your board. All of that is already existing in Georgia law. So there is a very inexpensive mechanism to allow you to hold your board accountable if you don't like what they're doing. And we don't think it's good law to make law based on a few rogue actors. Instead, recognizing there are already existing laws, and there are millions of very happy homeowners who live in HOAs and condominiums. A reporter told me last year when I tried to pitch a great story about an HOA, they don't write about the plane landing safely. They only write about the plane crash. And so we never get a news story about how happy and all the good work that the thousands of volunteer leaders do on behalf of their communities in this state. That's who runs associations, volunteers who also are the neighbors of these people who are complaining, and they can run for the board if they want. Regarding the foreclosure language, Georgia already has the highest threshold in the country. The $2,000 cap is already the highest threshold in the country. And so we do not believe that should increase even further. There's also a provision that prohibits an association from bidding at the foreclosure sale. The HOAs and property owners associations and condominiums are not like mortgage companies. They can't just go advertise and then go down to the courthouse steps and sell. They have to go through a statutory process already existing in Georgia law under the Property Owners Association Act that requires them to get a judgment with a court order to foreclose on the association's lien, and then it goes to a sheriff's sale. But you heard from one of the HOA board presidents, first you've got to send all these statutory notices, then you've got to have a lawsuit, then you've got to get the judgment, and the court has to agree that there should be an order for foreclosure for that ever to happen. Oftentimes, there's never a bidder at the foreclosure sale. This is a reality of this process. And so we believe strongly that associations should have the right to bid up to the amount of their lien, which is a mechanism often used to allow the property to go forward with a sale, and then it can be handled by the association afterwards. So we're hoping that that will be struck from this.
Due to the interest of time, I'm going to have to
Yep. No
just cut you
problem.
off. Now, and this was probably a mistake, you signed up for the support sheet, so I'm assuming you are in opposition?
I am in opposition,
Okay.
as were the two HOA board
Just
presidents.
clarifying that, and then Lisa Turner's with your same organization?
she is.
Is it okay if we wait for her time since y'all are with the same group? Because we got to move.
Yes,
Okay.
yes. So wrapping up, I understand you have time. We believe this interferes with contract rights that are set forth in the declaration that people agree to. That's recorded in the public land records for every county where communities sit. And we want to continue working with Senator Brass to make this work for Georgians who live in these associations. Thank you so much for your time.
Thank you. Okay. Last is Esther Bales.
Good afternoon. My name is Esther Bales, and I'm with the Canterbury Point HOA Association. I can make my comments brief because I completely agree with the lady that just spoke. I think what is happening with this legislation is that there are some bad actors. There are some bad HOA leaders. They probably shouldn't be on the board in the first place. And what our concern is that the HOAs that are doing it right, they're not punished or disenfranchised with this new law. My HOA has registered with the Secretary of State. We have all the processes I think that this gentleman described. So there are HOAs that are doing it the right way. And we just want to make sure that we can continue to follow our bylaws. We have a management company that helps us. Just make sure that we can continue doing it the right way, and we're not disadvantaged with this new rule. So those are my comments.
Thank you. Okay. Would you like to close?
Sure. So I do agree there are good actors and bad actors. We see it all the time up here. And unfortunately, when there's enough bad actors, we do have to act. And I've heard enough complaints from all over this state. In fact, I've even had a lady from Seattle, Washington call me about it. I told her I couldn't help her. But we do need to do something. Okay. And I have worked on this for about 1.5 years now with some of the people that have spoke, which I'm a little surprised spoke against it, but because they helped me craft some of this language. I'm not married to everything in this bill. There are some certain principles within it. The 4,000, I'm not married to that number. I am married to no portion of such amount shall include collection of fees or fines. I think that is just a mechanism that breeds people doing the wrong thing. It can be a neighbor that doesn't like their neighbor, and they fine and fee them until they can foreclose on their home, and that shouldn't. Nobody should have that power. So I am married to that portion of it. The $2,000, I'm not. If it needs to say 2,000, I'm fine. The reason I have the language in there about the no member of that HOA shall have the ability to purchase is because one of our very own senators is in a condominium where they are people or the board, and maybe it's one board member, are fining, feeing people, getting it to foreclosure. They are foreclosing. Our member is in foreclosure right now because she's refusing to pay the fines. She's still paying her dues. She's still paying her assessments, but she's being fined and being foreclosed on. And they are turning those apartments, those condominiums, into short-term rentals. And so that was why I put that language in there. Again, I'm not necessarily married to that portion of the bill, but the accountability, they say that there's laws out there to protect these people. Those laws have failed those people. Again, I agree, there are good actors. And for the good actors, the ones that are doing everything they're supposed to be doing, the only added layer that they're going to have to do every year is simply take the documents that they already have and upload it into the Secretary of State's portal. That's it. That's the only thing they're going to have to do. They can still do their fines and fees. They can still foreclose. They can do everything they need to do. And the only extra thing they're going to have to do is take documents that they already should have readily available and upload it. That's it. And then keep it around so that it's there. But the Secretary of State's going to have to keep it as well. So I will agree those laws are there, but they're scattered throughout our code, and they're not doing what they're supposed to be doing.
Well, thank you for your work on this. I know it is a big issue, and I know there are good actors. What I would like to do with this, because we are a little tight on time, and because I know it's a very important issue, I would like to entertain a motion to recommend this move forward to the full committee, but reserve any amendments until we get to full committee. Anybody entertain that motion?
So moved.
Moved. Is there a second? Second. All those in favor, raise your hand. All right, we'll recommend it moves forward to the full committee. Thank you. Okay, next up, we have Senate Bill 413.
Thank you, Mr. Chairman and members of the subcommittee. Come before you with LC 620253. And this bill, just as a, I'm glad they're not.
Those that are exiting the room, just don't mind keeping it down. We've got some more bills. Go ahead, Senator Jackson.
Just by way of quick, brief backstory, this bill came to be because I took a tour of Grady Hospital, and specifically their emergency room department, where all victims of gunshots go in the metro area. So it doesn't matter if you were shot in Alpharetta or right here in downtown. If you were a gunshot victim in the metro Atlanta area, you will find your way to Grady for the most part. And so we had conversations about the importance of disrupting violence in communities in particular. And I asked them, what can we do to help? How can we help end, this kind of cycle that you might see of retaliation where someone gets shot and then they go back, when they finally get better, they shoot somebody else. How do we end that? And they were just like, it would be really helpful if people could just move. And I happen to be familiar with being able to move because I carry the bill that allowed victims of stalking to be able to move out of their leases in order to get to safety. And those of you who came before me, you'll remember we also did this for domestic violence victims as well. What we as a body have decided is that if we can create a situation where people can just move and that might save a life, then we're willing to do that. And so that's really what this bill does in a nutshell. It's got some validators. You'll probably have some friends who will testify that it's too many people who can validate that you are a victim of that. I'm very open to changing that, but I hope that the concept, that the intent is something that this committee can certainly get on board as we work out and flesh out the details around it, because ultimately this will save lives. We know that if people can leave, then the likelihood of retaliation, the likelihood of being able to heal and just get better because they're no longer in that place of trauma could be really helpful. So I'll yield for questions.
Do we have any questions? Excuse me. Do we have any questions from the committee? Looks like Senator Beard. number 9.
Trying to go through this real quick. On lines 50, page 3, section 7, means the occurrence of one or more of the following acts against a tenant or legal occupant of a resident. Are we talking about the individual that's a victim of gun violence, or something happened with a gun in where the tenant's at? Are they actually the victim, or are they just someone that's saying something happened in the immediate vicinity of the residence? And they can.
The active word there is on line 51, against a tenant. So the act has to happen against the tenant. It can't just happen in the proximity of the tenant.
So an actual person is the actual victim that we're talking about when we say tenant here.
That's right.
Senator Still?
Thank you, Chairman.
Oh, what number are you?
5.
There we go.
Hey, Senator. Following up on Senator Beard's question, line 51, a tenant or legal occupant of a residence at or in the immediate vicinity. What is there a definition of immediate vicinity? And I guess what I'm asking is, hypothetically, a 100, just for simple math, a 100-unit apartment, and there's a domestic violence situation, who would be eligible for moving out of that 100-unit apartment or condo?
Just the person who was
Just the person affected,
harmed by
not the neighbor surrounding.
No, the act has to actually happen against the person. So they have to, and that's the part of the testament. They have to testify to the fact that this person was harmed or at grave risk of being harmed. So you could shoot and miss, or like you don't actually have to be shot in order to still qualify. But it does have to be specific. So it can't just be I was in the area and somebody was shot nearby me. It does have to be the actual victim. It has to happen against that tenant or legal resident.
I understand. Thank you.
Mm-hmm.
Do you have any other questions? All right, we got a couple people. We have 2 in opposition and 2 in support. Let's hear from Betsy with the Georgia Realtors first.
Me again. Betsy Bradfield, Advocacy Director with the Georgia Realtors. Thank you, Senator Jackson, for your work on this issue and your work on the stalking and the domestic violence bills previously. I do rise in opposition just because of the tightness of the legislation. So it was previously incredibly tight for who could validate those sorts of issues. And it involved essentially law enforcement validating that that's something had happened. This is just a little broader than we would like to see, because there are unfortunately some bad actors who are looking for any reason to get out of a lease. And if they can just say that they feel like there was a reasonable threat of gun violence, then you could see a lot of leases being broken for that reason, which is why we would oppose that. But if there is a tightening of the language and there is an expectation that someone did experience gun violence, or like you said, is in grave risk of it because they were shot at and missed, we would be amenable to that sort of tightening of the language and be okay with it, because it would bring it very much in line with the stalking and domestic violence bills previously, which basically defined a tenant victim versus a tenant offender, right? And the tenant victim would be able to break their lease without having anything appear on their credit or any sort of notice that would follow them throughout the lease. And they would be, harder to find. They would be basically taken off everything so that the offender would not be able to figure out where they went.
Thank you.
I'll stand for any questions.
Any questions? All right.
Think so.
Next, we have Hayden Stanley.
Thank you, Mr. Chairman, members of the committee, Senator Jackson. I represent the Georgia Apartment Association. My name's Hayden Stanley with the firm 5 Stanley, and it's been our honor to represent that industry for many, many years. And I think we've worked with each of you over that time. The Apartment Association is still very proud of having been hand-in-hand supporters of legislation that created the carve-out and the exemption for victims of family violence to get out of leases. We were also very pleased, I think, in your first week in this building, to support those efforts to include stalking. And as Betsy mentioned, those two provisions which are in your bill show that there either has to be a judicial order, or if it's an ex parte order, it has to be accompanied with a police report that supports that ex parte order. Those provisions are tightly drawn. They're specific to victims, and people I represent have been very comfortable with that. This legislation, however, does neither of those things. It's not tightly drawn, and it's not limited. A couple of areas, and I know that there were questions specifically. One is, as we look at the definition of firearm violence, which is on line 50, it means the occurrence of one or more of the following acts against a tenant of a residence or in the immediate vicinity of the residence. We've talked about what immediate vicinity means. And we go down through that A through D, including an action using a firearm that creates a serious risk of injury. So we think that that is so very broad. It could provide tenants of 100 units to submit to submit the documentation or the claim that they are at risk and a victim and therefore should be relieved of their contractual duties. Line 57 gets into a victim services provider. That's very broad. A qualified third party is I suspect we could all qualify for that definition one way or another. So if it is the policy of this Senate to include victims of gun violence or firearm violence in this very small and defined list of people, this legislation, this bill is not the way to do it. It's very broad. It's unclear. There's a section here starting on page 87, frankly, we don't understand what that applies to, what it means. We would just ask you to hold this indefinitely.
Thank you.
May I speak to his question about line 87?
Yes, we've got two people speaking in favor of the bill, and then I've got to hear Senator Burns' bill. So what we'll do with this, I'm going to let the two people in support go ahead and speak as well. But then we'll do this will be hearing only, and we'll come back so that the committee can address some concerns and work with you on that. So, but you can go ahead and address.
Yeah, just briefly. So what we've had, and you'll hear this testimony, is that people who've fallen under the current current legislation in terms of carve-outs, their landlords haven't said anything to them about the lease being terminated. So they'll submit the paperwork, and then they never hear back whether or not it's all copacetic. And so this just says you have to provide notice to the tenant that that you're going to let it happen.
Thank you.
That's what that's about.
Thank you. Yeah, absolutely. Number 11.
It just kind of helped. On the issue on the, like the qualified third party stating on line 81, and also I guess 75 victim service provider, would it tighten it up if we did like it would have to be a certified family intervention program? Like instructor or specialist, would that help? Would be in the right direction?
Certainly would check with the client on that, and I would need to present them with exactly what that is. I apologize, I don't know what their qualifications are.
Okay, thank you.
Thank you, Lee.
Absolutely. Well, you have certified programs in Georgia, so just curious as we're working on it.
Okay, thank you.
Thank you.
Yeah. All right. Karima Dillard.
Good afternoon, everyone. Thank you, Chairman. I'm Karima Dillard. I'm the Director of Policy for the Georgia Coalition Against Domestic Violence. And I feel like I've been saying this to Senator Jackson since she started, but we can't thank you enough for what you've done for victims of domestic violence and stalking. I can say anecdotally when I've asked our member programs, and by the way, for those of you who are not familiar with the Georgia Coalition Against Domestic Violence, we're the federally recognized statewide coalition of domestic violence shelters and community-based programs here in Georgia. And when I've asked advocates, you know, how well is this bill working? I'm hearing, oh, it's working for people who are eligible. It's working really well for people who are eligible. And I want to address what the gentleman just raised, the point he raised about the people who could certify, that many of us could be on that list. And as a licensed social worker myself, I've had education and training. I have a license. Nurses have a license. Clergy have some sort of certification. Community health workers go through training. Most of us would not be on that list. I also want to say empirically, I asked one of our legal advocacy organizations that covers some of the largest or most densely populated counties here in Georgia, how is this working? How many of these have you seen? Since 2021, they've seen 101 cases where a victim asked for this service by name. In 2024, we lost 174 people. In 2023, it was 163. We haven't gotten the numbers yet for 2025, but anecdotally, we're told that the number's going to be even higher. I can pretty much guarantee you that 101 number, those folks are not on the Remember My Name list. This bill saves lives, and it can save even more lives when other folks besides law enforcement and the courts can certify victimization. Most survivors don't call law enforcement. Most survivors don't want to involve the courts, but they will reach out for help. And we want them to be able to access the help that could save their lives. Thank you.
Thank you. So we've got some members that may have to leave at this point. Amber, is that who's next? Are you speaking in support?
Yes.
Okay. I've got two options. Either you can submit some written testimony, or if you'd like, when we have another hearing, if you could come back. We've got to move pretty quickly. I want Chairman Burns to have an opportunity to present his bill to the committee before we adjourn. And so this will be hearing only, and we'll call you up on the next one. I apologize. We're just running out of time.
We could just work on it in the main committee. That's also an option, sir.
Yep.
It'd be a great option, just to allow us to help move it forward and not slow it down.
I understand. Thank you.
Thank you.
Come on, Chairman Burns.
Thank you, Mr. Chairman. I want to thank the committee for their endurance. Reminds me a little bit of our ethics meetings over the past several years. I want to pass out a little bit of information, if I could, if you could help. I'll be very brief. I know the hour's late, and I know that we all have other commitments. But this is an important topic that I want to make sure that we at least hear it today. I'd appreciate action in the near term, if that's a possibility. We've had a large number of concerns expressed about the use of an individual's image inappropriately, where that image could be appears to be either nude or involved in some kind of an explicit sexual encounter. Most of the discussions that we've had on this issue have been criminal. I'd like to point out to you that the way that we often have to address bad use of good products is through the civil option. And what I've shared with you is from the National Council for State Legislators, all of the legal background that other states have done utilizing the civil component to remove or protect individuals from being violated. So first of all, let me quickly say, I hate lawyers. You know, I hate lawyers who abuse the law inappropriately.
You're in the wrong committee to say
I know
that.
that. Wait a minute, I'm not done yet. Who use the law inappropriately for personal gain. I love lawyers. I love lawyers who use the law to protect people's rights. This is a love-hate relationship. If you look at the criminal code already makes the use of someone's image a criminal act from a standpoint of sexualization. However, if you look at the concept of name, image, and likeness in our sports environment, I cannot use someone's image, Stetson Bennett, I can't use their image without their permission or without them having some remuneration. If you look at the O.J. Simpson case, even though we were not able to criminally convict an individual for an act, the family had the opportunity to address that issue in civil court. So, if you'll look briefly and quickly with me at SB 418, Section 1, subsection A, really just provides the definitions of what an image is, what an individual is, what a photograph is, what use or uses mean. The guts of the bill are in lines 21 through 30. An individual shall have a cause of action. That's a tort. I hate torts. I hate to be sued. I've been sued. I've had to protect myself inappropriately. But I hate people abusing my granddaughter worse. So, don't take my granddaughter's image and represent it as though it was doing something or providing some image that is totally disgusting. So, an individual shall have a cause of action against any person, irrespective of that person's age. Sometimes this is bullying, right? Sometimes this is bullying, so it's adolescent against adolescent. Sometimes it's pedophilia, adults against children. Sometimes it's adults against adults. But anyway, irrespective of such person's age, that uses such individual's photograph or image together with one or more representations in whatever form of nudity, sexual, explicit conduct, as such terms are defined in Code Section 161190, and that such person's use was with the knowledge that they were not authorized to use that image. So, it's pretty simple. Other states have used the civil courts to address inappropriate use of someone's image. This is not an AI bill. AI is a tool. It's a positive tool. It can be used positively or it can be used inappropriately or negatively. But at the end of the day, the use of an image without that person's knowledge and consent would be a violation of this statute and would lead to a cause of action. Now, if you look a little bit further down, you notice that in lines 31 and 35, it provides it for a time frame of 10 years after a child reaches the age of 18, or it also includes deceased individuals. Now, I want you to understand, we're looking at addressing the problem where we have an individual who inappropriately uses another individual's image. We're not talking about the product they're using. We're not talking about the medium that they use. We're not talking about whether it's an electronic medium or a physical medium. We're not talking about the issue of the internet or the internet provider. I did get a request, and I don't have a problem with it, and I'll be happy to share it with you. Both the Verizon and the Georgia Cable Association would like to provide an explicit amendment to ensure that no internet service provider, search engine, cloud server provider, or affiliate or subsidiary of any other the same shall be held to have violated this section solely for providing access. I'll be happy to provide that to the committee.
Okay.
And I'd ask that you consider that as a friendly amendment. I would also say I think we have a code reference opportunity. 1610, I think we referenced 1190. I believe that there was maybe someone can speak to that. We have an attorney can speak to that, would provide a more direct code reference to that. So I think those are two things that I am aware of that I'm comfortable with as a non-attorney that could potentially strengthen this bill. Remember, the objective here is to ensure that we protect the image of Georgians, adolescents as well as adults. You cannot use my image in any way to present me in a nude or a sexually explicit manner without my knowledge and consent. So with that, I'll be happy to take questions.
You got some questions, Senator Still?
Thank you, Chairman. Chairman Burns, how do you address the concern when last year we had SB 9, which was a little bit broader than this? This is much more narrowly focused, but a lot of folks got upset with that bill because they felt like it crossed into First Amendment, free speech. It's not harming anyone. These are all the arguments we heard, and this is why that bill didn't move. And I'm just wondering how this is different.
I think this is explicit. It explicitly says nudity or sexually explicit conduct. It's a representation of nudity or sexually explicit conduct without that individual's consent. I acknowledge the fact that this is a challenge, but I don't believe it's a First Amendment challenge. I do not have the right to defame you without recourse. So I would hope that this, again, if you look at the civil remedies for unauthorized disclosure concept from National Council of Legal State Legislators, NCSL, state senate, they have, this does not exactly follow their recommendations, but it's very close. And if you also look, if you look at, Georgia already has the criminal side of this challenge covered. I think actually the chairman has a bill that would strengthen that component as well. And again, my objective is not to create a large number of torts or lawsuits. My objective is to ensure that people don't abuse the image or likeness of someone else.
Well, Mr. Chairman, thank you for presenting that today. What I would suggest is if you could get that amendment drafted for the committee so we can have it at our next meeting. I know Robert Smith is here to testify. You're in the building frequently.
You also have the reference.
1 minute.
Yeah.
Okay, 1 minute. 1 minute, and then we got to adjourn.
Yeah, I got a question too.
Yeah.
And I apologize, I know the hour's late, thank y'all for
It's
doing it.
not late. We stay a lot longer than this.
Basically, there's a code reference in here to 161190. The problem is that in 161190, it didn't refer on sexually explicit conduct. It then refers you back to 1612-100. All I'm saying is that rather than making a reference to a reference to a reference, just go ahead and say that nudity as defined in 161190 and sexually explicit conduct as defined in 1612-100. Keeps everything nice and tidy. Everybody knows where to go to look for the things. And that's all I've got.
We appreciate that.
Thank you. And I certainly accept the wisdom of the committee on that and the recommendation.
Senator Parent?
Oh, thank you. Thank you for bringing this, Senator Burns. When I read the uniform code and how it sort of describes it, I have a much better idea of what your intention is with this legislation than I actually did when I read the bill. I think that to me, this reads like, I can't tell if it's like someone posts on Instagram and there's some photo of me, like I'm sitting here now, and then after it comes some photographs in one sort of package, that have some nude nude photos of something else. It's, to me, very,
I believe the intent is if someone were to use your image and make you appear to be nude, or you as an individual appear to be involved in some sexually explicit conduct.
but your intent is not to get into AI.
No,
Right.
let me say, AI is simply the product by which someone could do this, but it's not limited to AI. I think AI, the tool itself, is a positive tool, and it can be used for positive things. Some people are using the tool for negative things. Let's go back to the analogy of a Smith & Wesson handgun, since we love to talk about guns. If I use that weapon criminally and I injure someone or kill them, I'm the responsible party. It's not the weapon itself. The weapon itself was the product or the tool. Was it used correctly? No. Who was responsible? Was the vendor responsible, or was the individual responsible? I mean, we're going through the tragic situation up at Appalachia High School right now. And there's been some discussion about should a parent be responsible for their minor child's conduct? And the answer is, in my mind, yes. So I would suggest that the tool or the product that's used to produce the image is not what we're looking to address. We're looking to address the fact that someone inappropriately used that tool to represent another individual in an explicit sexual or a sexual conduct matter, or in a form of apparent nudity.
Well, Mr. Chairman, it seems like we've got a couple different fact scenarios we might be dealing with here. What's contemplated more on this is like someone has nude images and either is sort of extorting the person or sharing them without their consent. But what I'm reading here and what the chairman's testifying to also get into other categories, and I just want to flesh those out before we sort of take any
I
action.
appreciate that. And I appreciate that. I would suggest that this can be used in cyberbullying. This can be used in extortion. This can be used in any number of ways that are unacceptable. But I'm happy to work with the committee, and I welcome the committee's input. Again, I think our objective here is to find a way to protect people from being defrauded and being abused and being humiliated.
I think we're all on the same page. I'm going to let Senator Bearden close us out with the last question here. Senator Bearden?
Two-part. First one.
Only one. Pick one.
Oh, gosh. I'm going to make this a long question then. How close do you think we keep on protecting the product that can put someone's face on a nude body? How far away do you think we are before we're able to hold that platform liable for that?
I would suggest to you that that's a very difficult goal to achieve. And I would suggest to you that the product that would provide the mechanism to do this is oftentimes out of reach of Georgia's enforcement capacity. And at the end of the day, the individual used the product in an inappropriate manner, and they should be held accountable.
And I'm going to follow up one last thing, I'll be done, because if you go to AI, it will tell you it's almost 100% certain it can have the difference between a real photo and a AI image. But I'm also can tell you that no one can get on this phone without my face looking at it. So I think we're real close to being able to say my image can't be used for anything, but I think that may be something we need to look at.
I
sooner
think
than
this
later.
protects the image of the individual. It
And that's what I'm
protects
trying to
the
do.
image of the individual, which is what I'm trying to do.
Senator Jones.
So my question is, the plaintiff in this case would have to show that the defendant knew that he was, okay. so this-
Knowingly.
Correct. But here's my question, and Robert may help me, or legislative counsel may help me. Should children be separated out of that? Because you can't have sexually explicit images of children regardless of your kind of like intent, your knowing intent. So I'm actually wondering if we should separate the child aspect out, because to say that a child would have to prove that they knowingly understood,
Well,
they can't have it.
The child cannot consent.
The child cannot
Child
consent.
cannot consent.
Right.
But this thing says parent or legal guardian. So if it's an adolescent on adolescent expression, inappropriate use, then the child, the underage child, could never consent to their image being used. So there's almost a situation where you have a guaranteed violation. The individual using it, whether they're an adult or a child, has a responsibility to not violate that image.
But they can't even have it.
Well, they have it. You may say that, but the reality is those images and this technique is reality.
No.
So I would agree with you. They should not have those images legally, criminally. The challenge with the criminal court is it takes a very long time. It requires an enormous amount of legal maneuvering to get a conviction. In this case, this essentially provides the violated individual with an immediate recourse to say, stop using my image. It's not intended, it can be criminal, and by the way, the bill points out that this statute is in abeyance if there are criminal charges and the criminal proceedings are moving forward. So it always takes a secondary position. But at its face, as soon as someone violates my image, I have the ability to immediately have them stop or be in violation and potentially have civil damages.
Right, but you'd be able to show the civil damages like you just had to show their knowledge that you didn't approve it.
Again,
that's what I'm getting
again, if they do not have consent, and again, in a contractual environment, typically that would be written consent.
Well, actually, I'm trying to actually help it make it easier for the child to be able to sue. I'm saying that gives me concern to say that they can't have consent. The child could never consent. So it might be better to make it almost like a strict liability situation for children's images.
There's the potential that a parent could provide the consent, but that would be a crime as well.
A parent could never provide a consent for sexually explicit images.
I know.
Right.
I hear you.
I think this would be a good conversation for y'all to continue. We are out of time. Thank you, Mr.
Well,
Chairman Burns.
I just want you to know, Mr. Chairman, that the first shall be last, and the last shall be first.
You're going first
So
next time, I promise.
I'm happy to take that first.
Thank you. Have a good one.
Thank
This meeting is adjourned.